illustrations. Never have I been in a case in which a federal prosecutor saw fit to keep filing new indictments, 7 superseding indictments in this case, just to make it look as if there were more and more criminal charges, when really it was the same charge, just fragmented into minute separate counts so that the accused will look more guilty to the media, to the public, and ultimately to a jury. And most of American Jews watched and remained silent. Never in the history of the United States has there been a case in which anyone has been charged criminally because he paid a cattle dealer a few days late for cattle that he had purchased. The federal prosecutors saw fit to add such a criminal charge under a 1926 law that had never been criminally enforced, on the ground that Shalom Rubashkin paid late, even though he paid every cent he owed to cattle dealers, a few days late. American Jews watched this and remained silent. The prosecutors resisted moving the trial of this case out of Iowa, but the federal judge finally had no choice when she read the responses that potential jurors had given to a questionnaire testing their prejudices. Was the trial moved to Chicago or to Minneapolis, as the defense requested, where it was most likely that the jurors would not be prejudiced by media reports in Iowa? No. The judge moved the trial a few miles across the border into South Dakota, a location that had been influenced by the Iowa media. No objection from American Jews. They remained silent. There are so many ways in which Shalom Rubashkin's trial on 91 federal counts was unfair. I will be dealing with those issues in his appeal from the outrageous 27-year sentence that Judge Reed announced in a written opinion today. I won't detail those grounds for you tonight, but I do have to comment on the sentencing process. The prosecution initially requested that Shalom Rubashkin be given a life sentence. When they heard of this recommendation, 6 former attorney generals, 2 former solicitors general, 25 former United States attorneys signed a letter of protest. I personally spoke with some of the former attorneys general, and they were outraged by the prosecutor's request. So the prosecutors toned down their demand. They told Judge Reed that 25 years in prison is enough for this crime of bank fraud. The crime of drawing more than Shalom Rubashkin was entitled to draw on a $35 million line of credit that he never exceeded. And remember, until agri-processors went bankrupt because of the raid, it was paying timely interest on every penny of the amount it borrowed. The prosecutors who made this recommendation are, to be sure, honorable men. What did Judge Reed do in these circumstances? Did she take account of the fact that for a 51-year-old man, the 25 years the prosecution was asking for was equivalent to a life sentence? Did she ameliorate the punishment in the slightest because of family considerations, or because Shalom Rubashkin did not intend to cause any loss to the bank? This was a test of how well the American judicial system works. Now make no mistake, we live in a Malchus shel Chesed, where Jews have been given rights and liberties and freedom unparalleled in our history and goals. We cannot expect American justice to be administered by the standards of the Sanhedrin or historic Batei Din. We learn those standards these very days on the pages of Daf Yomi that's being studied around the world. Would Shalom Rubashkin's payment of timely and full interest on agri-processors to the agri-processor's bank for any excessive draw he improperly made on the line of credit be punished at all if American law followed the principle discussed in the Mishnah in yesterday's Daf Yomi, that Kol mitzvos lo sase sheyesh bo kum biaseh ein kayom in. A prohibition, such as the taking of an excessive draw, that's corrected by an affirmative obligation, such as paying full and timely interest, ein kayom in. American law shows no similar compassion for the wrong that can be made right, nor does American law consider whether onshim in hadin or mashirim in hadin. Once one looks at Daf Yomi, by the way, it's remarkable that on the very day set for Shalom Rubashkin's sentence, the Daf, today's Daf, tomorrow, today, almost out of the blue, in the midst of discussing Lav Habon Miklal Essay, cites Rava's proof from the Pasuk in Re'eh that defines kosher animals. No one did more to make kosher beef accessible to the Jewish population of the United States, wherever they may be located, in Wyoming or North Dakota, than the Rubashkins. By packaging and marketing meat that met the very highest standards of quality and packaging so that it was most attractive to the buyers of the leading American supermarket chains, the Rubashkins placed kosher meat within the reach of every American Jew. Pirkei Avos tells us that kana shein tov kana liatzmo. One who gains a good reputation has gained it for his own benefit. But the good reputation of Shalom Rubashkin, gained because of his personal tzedakah and masim tovim, was augmented by the good reputation, the shein tov, of agri-processors' products in the marketplace. And that combination was not the atzmo, but it was for the benefit of all America's Jews. What was done to Shalom Rubashkin was not a prosecution, but a persecution. How else does one explain the Iowa Attorney General's announcement that he was charging 9,311 counts of child labor? That was an act of a prosecutor overcome with envy of the federal prosecutor's monopolization of headlines. How could the Iowa Attorney General beat 7 superseding indictments and 163 criminal counts? By filing 9,311 charges. But by the time his charges went to trial, they were reduced to 83. And then to the jury down to 67. This jury heard the evidence the law permitted it to hear and nothing more. And it found Shalom Rubashkin not guilty on all 67 counts. A sports fan would wonder at a batter who is up 9,311 times and strikes out every time he gets up. And yet, through all this, most of America's Jews, with the exception of Yated Ne'eman, Kenny Lifshitz, Yahuda, this community, Chabad, the rest, just watch silent. The time has come, particularly after the incredible sentence that was announced today, for America's Jews to be silent no more. The time has come to speak for Shalom. The time has come to shout for Shalom. His name is Shalom Mordechai. Rashi Tevos make the word shame. A good name that has been unjustly shattered. But more than that, if you add his family name, add a resh for Rubashkin, you get Shin Mem Resh, Shamor. Guard him. Watch over him. We know the word Shamor. It starts the 4th of the Aseres HaDibros. Shamor Shema Shabbos V'Kadsha in Vaskana. We also know its compatriot, Zachar,
which starts the 4th of the